Industry Expert Review by David Shapiro. The podcast that I have selected is via Entertainment Law Update with Gordon P. Firemark. Episode 28 goes in depth in regards to certain violations of copyright and trademark. Entertainment attorney Firemark discusses a case that has been filed. The Warner Brothers subsidiary was challenged by Mark Towell, a Temecula, California mechanic who in 2011 was sued for selling replicas of Batmobiles from the 1960s TV show and 1989 film. Towell, who sold his replicas for $90,000 apiece, argued that the Batmobile is merely functional, a useful article, legal speak for a utilitarian tile terrene, rather than artistic object. Gordon, 2015. Attorney Gordon supports how the Batmobile technically is a piece of property that DC designed. Here we conclude that the Batmobile character is the property of DC, and Towell infringed upon DC's property rights when he produced unauthorized derivative works of the Batmobile as it appeared in the 1966 television show and the 1989 motion picture. Gordon, 2015. The judge of the Batmobile case in Los Angeles decided that the design of the Batmobile is protectable by copyright. Mark Towell, the man who is being sued by Warner Brothers, DC, appeals the decision made by the Ninth Circuit Court. Towell asks the Supreme Court 3 questions. 1. Whether a court may judicially create a subject of copyright that was specifically and expressly excluded by Congress as such when Congress enacted the Copyright Act, thus circumventing the clear mandate of Congress and the U.S. Copyright Office. 2. Whether an automobile that does not display any personality traits or any consistent and widely identifiable physical attributes can be separately protected by copyright as a character. And 3. Whether a determination of substantial similarity of protected expression must be made in a copyright case, independent of proof of copying. Gordon, 2016. It is unclear on what the decision will be if the Supreme Court is to even look at this case. Let's be clear, the chances the Supreme Court picks up this case are probably more slim than Christian Bale reprising his role as Batman. The High Court only grants a few of the thousands of cert petitions it receives each year, and there is not much of a circuit split on this issue. Towell tries to manufacture one by arguing that the law in every circuit except for the Ninth Circuit is that the design of an automobile, like the design of any other utilitarian object, is not eligible for copyright protection. But it would be a lot stronger if he could explicitly point to a case somewhere else in the country where a judge ruled out copywriting an automobile character. Gordon, 2016. In summary, it is obvious that attorney Gordon P. Firemark's podcast gave me great insight in regards to copyright and trademark. Only time will tell if the Batmobile case is to be picked up by the state Supreme Court. Here are my references, information, and images. Have a great rest of your day.